Good morning. Did you catch that from Mr. Calbar that his client, position 26, Tony Turner, is not going to be needed today?
What's the position and the name?
It's position 26, Tony Turner.
Okay, Tony Turner, that's your guy. Okay, so he's not gonna.
Okay, so,
Okay,
all right, just wanted to make
Got it.
sure that you know. Good morning.
good morning, thank you. For the first, I do have a quick announcement. We do need a
Okay.
Spanish interpreter for position 21, Mr. Roman Pardo.
Okay, Mr. Jordan, are you with us?
I'm here, Judge.
Good morning. So
Good morning.
are we going to have a Spanish interpreter this morning?
I can get someone for the report.
Okay.
Probably be.
Okay, so we'll see if we can round someone out.
Okay. Our first position is gonna be from the probation revocation calendar, positions 1 and 2, Mr. Derek Pass.
Good. And let's see, who's representing Mr. Pass this morning?
Attorney McLean is walking over, Your Honor.
Okay, thank you, Mr. Davis. Good morning.
Morning.
Good morning, Mr. McLean.
Good morning, Your Honor.
And good morning to you also, Mr. Pass. I'm Judge Eric Morrow. This is the probation revocation calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes.
Okay, thank you, sir. Good morning, Officer Allison. How are you today?
I'm good. How are you? Good morning, Judge.
Good. And where are we with Mr. Pass?
Yes. Are we ready to?
Yes,
Okay.
yes.
He was sentenced to probation in February, on February 2nd. He was to have no further contact with the victim, Latricia Pass, submit documentation for medical health evaluation and complete treatment. And he was also supposed to pay restitution in amount of $500. He did pay $200, so there's still a balance of $300 for the restitution. We was made aware that he made contact with the victim, Latricia Pass, and he has 7 months and 1 day left on probation. Probation is action to revoke.
Okay. Mr. McLean?
Your Honor, it is correct. He did his best so far on the $500, having come up with $200 on the broken window. It's a broken window at the home. He tells me that he was off his meds and not quite back on his meds at the time when he made contact with his mother. So he's basically throwing himself on the mercy of the court because that contact with his mother in violation of his probation is the point the probation department is making. And he's saying, well, I was off my meds. I'm better now. It was my mother. I do understand it's important to follow the prescription of the order, the sentence that I received. And so he's asking for a second chance.
Had he been reporting to probation appropriately?
Had you been seeing probation?
Yes.
Officer Allison?
Yes, he missed 1 day in April,
And how often is he supposed to report?
once a month. He did come in February and he did come in March.
Okay. And what day did do you have the day that when he contacted his mother?
I can look it up for you. It was on April 6th.
Okay. And Mr. Pass, you do understand that no contact means absolutely no contact. You understand that?
Yes, sir, I do now. I did,
Oh, hold on, Mr. Pass. I want Mr. McLean to speak for you. Okay, I just want to make sure that that you know that you cannot be in contact with your mother. What's the issue on the mental health evaluation? Why has that not been completed?
did that mental health evaluation that was diagnosed with anxiety.
Did you get it over to the probation department?
Yes, sir.
He says he's got it done and turned in. Is that correct, Ms. Allison?
We do not have anything on file.
He's naming to me what the diagnosis is, so it sounds like as a layperson, he probably wouldn't know those phrases unless he just needs to get it to you. Do you have it handy? I mean, where is it?
Well, I have a copy. I have, gave him a copy, but he said it had received, and I had kept a copy myself.
Where's the copy now?
It's somewhere like, what's that? Oh,
Is that in your property bin?
no, sir.
Okay, where's your bag in your folder?
It's at a shelter.
At the shelter. Which shelter? Is it one of the Salvation Army? Is it Atlanta Mission?
But I can get the copy to them. He has the date on it and everything.
Okay. He believes he can get a copy. It's in his backpack, and that property would be at the mission.
Okay, so I want him to complete what he has promised the court that he's going to do by paying the restitution to his mother. So I'm going to return him to probation. Within the first 2 weeks, Mr. Pass, you are to get that. You're telling the court that you've done the mental health evaluation. So within 2 weeks, you're to get that mental health evaluation to probation so that we can check that off of what you were supposed to do. You're not to miss any appointments with probation. If you miss any appointments, I'm going to have Officer Allison bring you back here, and I'm going to accept the recommendation of probation that we revoke the time. If you either miss any time or you have any contact with your mother. No contact, and just so I know that I've told you, Mr. Pass, means absolutely no contact, no phone contact, no personal contact, no email contact, no social media contact, no contact whatsoever. I'm going to give you this one opportunity to do the right thing, but if you don't do the right thing, then you're going to be back here and you're going to be right back where you are. You understand me?
Yes, sir.
Okay, so I'm going to give you that opportunity, Mr. Pass. Good luck to you.
Thank you.
Thank you. Well,
Position 19, Peoples.
This is going to be a negotiated plea.
let's see. Yes, Your Honor, that is the negotiated one.
Okay.
Would you like the state's recommendation, Your Honor, or?
Yeah, let me speak to him just a moment
Okay.
first. Good morning, Mr. Peoples. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes, sir, I do.
Thank you. Can you raise your right hand for me? Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Okay, you can put your hand down. Thank you, Mr. Peoples. Yes, Mr. Walker.
Yes, Your Honor. The state's recommendation is 12 months to serve 60 days, credit for time served 15 days, balance probated with the, excuse me, with the conditions of 40 hours community service, no further contact with the victim whose name is Samia Daniels, and a stay away from the incident location. Address is 3215 Cushman Circle.
Any objection to the probation terminating when he completes the terms?
None.
Okay. Mr. McLean?
Your Honor, he agrees that he has no reason to be at that location. He will stay away and have no contact. We had a full discussion with me of the advantages and disadvantages of deciding on the negotiated versus the unnegotiated route, and has decided to opt for this route. He asked the court to accept the recommendation. It is a joint recommendation, and he stipulates to the three necessary elements.
Thank you. Mr. Peoples, it's my understanding that in case 23 CR 002564F, you wish to plead guilty to loitering and prowling. Is that correct?
Yes, sir.
Are you under the influence of any drugs or alcohol this morning?
No, sir, I'm not.
You've been represented by counsel. Are you satisfied with his representation?
Yes, sir.
You understand that you have a right to a trial by jury on this charge, and that by pleading guilty to it, you're giving up your right to a trial by jury?
Yes, sir.
Has anybody forced or coerced you to plead guilty?
No, they haven't.
Okay, I'll accept the plea as negotiated, Mr. Peoples. When you complete the 40 hours of community service, the probation is going to terminate. So the sooner you get that done, the sooner you're not going to be on probation anymore, okay?
All right, sir.
All right, good luck to you, Mr. Peoples.
All right, thank you.
Thank you, Your Honor.
Position 24, Stollard.
Oh, that one, we need to speak to him first, Your Honor.
Okay, can I get you to speak with him, and can we move on to maybe one of Mr. Dodez's cases?
That would work. Wait, Dollar.
Positions 1, 2, and 3, Mr. Booker.
Mr. Dodez, do I need to arraign Mr. Booker, or are you going to waive arraignment?
No, Your Honor, we'll be waiving arraignment on positions 1, 2, and 3. We would wish to address bond on position 3.
Okay,
Your Honor, I don't have the calendar for today. I'm waiting to get one right now. I should have it like in a second.
okay. Can I give you the case number or the name? Are you able to help me?
What's the
Or
name?
maybe I can, Mr. Young, do you have the history for me?
Give me just a second. I believe I do. Okay, Mr. Booker. Yes, Judge, I have his history.
Okay, thank you. Let's see, and since it's just a bond hearing, what's the history, Mr. Young?
Yeah, and I'm showing that he's currently in custody for possession of a firearm and possession of marijuana. The case number for those cases is 23 CP 217904. He also has the three battery family violences against the same victim, including a cruelty to children, that's position 1, and simple battery. Outside of what's on the calendar, he has arrests from 2019 for simple assault strangulation. Looks like that was dismissed. He has a conviction for a felony drug conspiracy from 2013. He has a disorderly conduct and criminal mischief, which was also dismissed in 2019. And forgery bad checks, he was arrested for it, but it was dismissed as well, along with a simple assault that was dismissed in 2013.
Okay, thank you. And do you have his bond, present bond on position 3?
Yes, Your Honor. The present bond is a $5,000 cash bond. The state would wish that bond to stand, given this offender has committed the same battery, family violence against the same victim on 3 different occasions. First one being the 12/18/21, the 3/17/2022, and then position 3 that we're addressing today is 1/6/2023. The state does have some concern against this offender reoffending, given the fact that he keeps committing battery family violence against this victim. And in multiple occasions, he has caused some visible injuries, obviously, blood streaming down her face, in this case from a busted lip. The last case, he grabbed her hair and pulled it to the ground. There was a laceration to her neck. It was swollen and bleeding. That was the 3/17/2022 incident. So with all that being said, Your Honor, we would ask the bond to stand at $5,000 cash. And he's also in custody on the $10,500 surety bond for the possession of marijuana and the possession of firearm.
And this cash bond, did I issue that?
I'm not sure, but I can try to look and see.
Okay. While you do that, Mr. Dodez?
I apologize.
Apologies, Your Honor.
You did issue that cash bond.
I did, Ms. Strong?
Yes, sir.
Okay, thank you. Good morning.
Good morning.
Okay, yes, Mr. Dodez.
Thank you, Your Honor. Mr. Booker is 32 years old. He has been in custody the past 18 days on a $5,000 cash bond on this case. We would ask Your Honor to convert that to a $5,000 surety bond that will allow Mr. Booker to hopefully work on bonding. I don't believe it'll release him immediately. As we heard from the pretrial report, I didn't hear, the last conviction was drug related in 2013. And I didn't hear any history of FTAs or VOPs. I have a good phone number for Mr. Booker. I don't believe he's a flight risk. He's settled in Atlanta for the past 3 years. And I have a good address for him that is not the incident location. It's with his aunt, Darla Daniels. Mr. Booker does have his GED, and he's currently a cook and worker at the Sterling Spoon Social Kitchen, which he believes is still, he believes that job is still waiting for him. But the longer he sits, the more likely that position will be filled. My understanding is that I believe I saw Miss McGee. I haven't spoken with Miss McGee. She is the alleged victim. If the court wants to sound for her and speak with her, or ask about any concerns, if she wants to be heard, if she's just here to observe, I understand. But I did want to acknowledge that the alleged victim is on the Zoom. We would ask for a $5,000 surety bond. Mr. Booker does share kids with the alleged victim. If possible, if we hear from Ms. McGee, we would ask for no further violent contact. But if that's not a possibility, we would ask for third-party visitation to ensure that Mr. Booker is able to have contact with his children.
Yes, I saw that there was a note from Ms. McGee. If Ms. McGee, if you would like to address the court, you certainly do not have to, but if you would like to address the court, now is your opportunity to do so. If you would like to address the court, I need for you to activate your camera, unmute yourself, and raise your right hand for me. Do you swear or affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Okay, you can put your hand down. Thank you, ma'am. What would you like to tell the court?
I just wanted to tell you that me and Mr. Booker, we moved out here together alone. And on our journey out here, I got pregnant. Before COVID, like I told you last time, I was on an invasive medication for hearing auditory hallucinations. And each time that these incidents happened with Monte, I was getting regulated on medication or was on the wrong medication. And I have a history, like literally appointments I made before the first incident or a week before the pills I was supposed to take. And he was basically, I was making it like an environment where I'm like a schizophrenic. So I was scared and nervous. All he was trying to do was help me and prevent me. And the only reason he kept coming back because he has other places to go is because he loves me and he wants to see me with my kids. And I just really would just hope that we could have at least contact for him to see my kids.
Okay. Thank you, ma'am.
Yes, sir.
Given the other, and I'm the one who issued this bond. It's a $5,000 cash bond, which if you've been to my court before, you know that that's unusual for me. I remember this case from when I issued the bond. I don't see that any of the circumstances have substantially changed since I issued the bond. I will leave the bond as it is, but I will modify it in the event that he does get out. Then he can have third-party transfer for visitation with the children. But otherwise, the bond remains the same. Good luck to you, Mr. Booker.
Position 14, Mr. Hunt.
Ms. Rockwell, is this your client?
It is, Judge, and I want to thank staff for contacting me. I did not realize he was back on for today. I have pre-tried the matter with the prosecutor, and he has other things that are actually keeping him in jail right now, Judge. I don't I have to get paperwork to Your Honor if the court, I'm scared to move the case with a guilty plea. I'd like to move the case with a no-low plea, but I don't think that's going to happen by consent unless the court is willing to do that. But do I not have to submit paperwork if that's going to happen, Judge?
Yeah, we'll have to get paperwork for Mr. Hunt to fill out with the plea form. So we can do one or two things, Ms. Rockwell. If you want me to put this on a calendar, I've got the SAP calendar on Thursday. If you want me to put it on that calendar for you to complete that, I'm happy to do that. If you just want, if you want to plead not guilty and for him to be returned to the division judge, I'm happy to do that also.
Why don't we try to put it on for Thursday so I can get,
Okay.
how do I get it to you, Judge?
Attorney Rockwell, I can send you the paperwork.
Okay, but I just, as far as sending it back, and then we'll try to.
I'll make sure that we get it to the right party.
Okay, all right, thank you so much.
Okay, so I'll see Mr. Hunt, and Mr. Hunt, I'll see you back on Thursday. Good to see you also, Ms. Rockwell. I hope you both have a good day.
All right, but you got the best staff in the courthouse. They called me when I was getting off of an airplane. So I'm over here. I said, let me just get settled somewhere. Thank you.
All right, have a good day.
Thank you, Judge.
And I see that we have the Spanish interpreter on the line. So courtroom 2, whenever you all want to deal with that, I think we probably will need a breakout room. So just let me know.
Position 15, Jackson.
And let's see, do I need to arraign him, Mr. Dodos, or are you going to waive arraignment?
Yes, sir. I'll be waiving arraignment. I'll submit that waiver. We did want to address bond, but Mr. Jackson has asked for a second to speak with me. If I could have him on mute.
Okay, that's fine.
Thank you, Your Honor. I believe we're ready to proceed.
Okay. What is the current bond, Mr. Walker?
It's a $4,000 total. I'm sorry, $4,000 total surety bond, $2K on each count. You issued this bond at the end of last month.
And what's the history?
I'm showing that. I'm sorry. Go ahead, pretrial.
That's okay. I'm sorry. The defendant has 5 arrest cycles. He has 2 open cases, 21 CP 198510 for willful obstruction, with 2 counts of willful obstruction of law enforcement by use of threats of violence, and a 23 CPK, so 23 CP 217980 for possession of Schedule 1 controlled substance and battery family violence. Let's see. The defendant has a misdemeanor conviction out of Clayton County for battery, criminal trespass, 2 counts of battery and criminal trespass out of Clayton County. Disposition date on that is February 2021. And last arrest was out of Fulton County on July 2022 for impersonating a public officer or employee. It looks like that case was dismissed on April of 2023. Nothing to add, Your Honor.
Yes, Your Honor. And just to clarify, that case that he's also being held on 23 CP 217980 is also with the same victim, Ms. Kira Shaw. And it's my understanding that he was booked in on this charges before the court because of the subsequent incident happened, which was the felony case. But in the misdemeanor matter, police was dispatched to 1829 Deloe Street. They spoke with the victim, Ms. Kira Shaw, who advised that the defendant had grabbed her, pushed her into a wall, put her into a headlock, and drug her out of the store that she was in. Law enforcement was able to speak to a nearby business and get surveillance footage that corroborated Ms. Shaw's statements. At that time, the suspect was no longer on the scene, but warrants were taken out for the simple battery and the battery family violence. As I just spoke to, a subsequent incident happened, which was a felony matter. At that time, he was apprehended on the felony matter and the matter that's before the court today. There is a $4,000 total surety bond in place that you sent back in April, and we'll ask that the court keeps that intact. Nothing further.
Mr. Dodes?
Thank you, Your Honor. My client has a question. Wait a minute, put it on mute again. My apologies, Your Honor. We're ready to proceed.
Okay, proceed.
Thank you, Your Honor. Mr. Jackson is 28 years old. He's been held in custody for the past 16 days on a $4,000 surety bond, which he cannot afford to pay. Hearing from pretrial, I didn't hear any history of VOPs or FTA, so I believe that he'll be good to show up to any and all future court events. I have a good phone number for Mr. Jackson. He spent the last 2 years in Georgia, where he came for a new life, where he's currently working. I do have a good address for Mr. Jackson. It's on Ashwood Avenue. That's his grandma's house, Miss Annie Witherspoon. So if there is no further contact order would remain in place, Mr. Jackson would have a location to stay at where he wouldn't have any problem staying away from the alleged victim. Mr. Jackson's a high school graduate. He's currently working in security services. He works with Title Max, TJ Maxx, and he contracts with nightclubs and hospitals in the area, and that's his livelihood. Mr. Jackson also has a 4-month-old girl that he is financially responsible for and wants to remain a part of her life. I would ask, I didn't hear if Mr. Walker or anyone from the Solicitor General's office had spoken with the alleged victim, or if the victim advocates was on the line to see if she wants to have violent contact with Mr. Jackson, but Mr. Jackson cannot afford the $4,000 surety bond on this case, and we would request a signature bond to allow Mr. Jackson to be a part of his defense, as he does maintain his innocence in this as well as the other open case.
Walker has, in response to Mr. Dodes' question about contact with the alleged victim, do you know if there has been?
We have not had any contact, and that is the reason why we are asking for the no contact to remain in place, since we haven't made contact with the victim.
All right. I don't see that any circumstances have changed since I issued the bond. I'm going to leave the bond where it is at the present time. Good luck to you, Mr. Jackson.
I have position number 26, Mr. Jenkins, and Mr. Dotis. I'm sorry, position number 16. Mr. Dotis want to do a breakout session.
Thank you. Yes, I have, if I can get a breakout room on my laptop, and I'll speak with Mr. Jenkins.
Okay, so that's at 4 North. So if we can put those into a breakout room and I guess go back to one of Mr. McLean's cases that is in courtroom 2.
Okay, Judge, that's Mr. Dotis in courtroom 4 North, you said?
Yes, I believe so.
Okay.
Thank you.
Your Honor, 24 and 25 are ready. I do still need to speak to Mr. Rutledge, so he won't be ready until I talk to him. And I understand the Spanish interpreter is available for breakout room.
Yes, so let's see, position 24 and 25, are they in the courtroom with you, Mr. McLean?
Stollard is the person I just talked to, so yes, on both. Yes, on both, they're both here.
Yeah. Position 25, Mr. Thomas. Come on, Mr. Thomas.
Okay.
This is a MARTA case, Your Honor.
It's a negotiated plea?
Yes, it is.
Alrighty.
Good morning, Mr. Thomas. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes, sir. How you doing, boy?
I'm doing fine, Mr. Thomas. I hope you are as well. Can you raise your right hand for me? Do you swear or affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Okay, you can put your hand down. Thank you, Mr. Thomas. Mr. Walker?
Yes, it's a time served offer of 16 days, balance suspended, with the condition of remaining compliant with any active MARTA suspensions.
So that's anything that MARTA is saying to you about suspensions, you have to honor that. We talked about that last night.
Right.
So, Your Honor, he would like to offer a negotiated plea to the court, ask the court to accept that under those terms that the state mentioned, and he stipulates to the 3 necessary elements.
Mr. Thomas, it's my understanding that in case 23 CR 002537G, you wish to plead guilty to certain acts, bus, rail, or station that will prohibit it. Is that correct?
Yeah.
Yes.
Are you under the influence?
Yes.
Are you under the influence of any drugs or alcohol this morning?
No.
Are you? Say it again. Are you?
No. No, sir.
No? Okay. You've been represented by counsel. Are you satisfied with his representation?
Yes.
You understand that you have a right to a trial by jury on this charge, and that by pleading guilty to it, you're giving up your right to a trial by jury.
Yes.
Has anyone forced or coerced you to plead guilty?
No.
I'll accept your negotiated plea, Mr. Thomas. Now, you know you can't go back to MARTA if you have an active suspension. You understand that?
Yeah.
Okay, so, all right, so don't go back to MARTA while there's a suspension. Good luck to you, Mr. Thomas.
All right. Thank you, sir.
Good luck. Stay away from MARTA.
All right.
Position 24, Stollard.
Come on, Jackson, people are fast.
And what are we doing with Mr. Stollard?
That's a negotiated plea as well, Your Honor. It's a simple time served.
Okay.
Anyone got it?
Good morning, Mr. Stollard. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes, Your Honor. Good morning.
Thank you. Good morning. Can you raise your right hand for me? Do you swear or affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, I do.
Okay, you can put your hand down. Thank you, sir. Mr. Walker?
Yes, it's another time served offer of 20 days, balance suspended, with the stay away condition of Walmart at 5200 Windward Parkway.
Mr. McLean?
Nothing to add, Your Honor. He does accept the terms of the negotiation, and he wishes the court to accept that as well. He stipulates the 3 necessary elements of venue, identification, and factual basis.
This meeting is being recorded.
Mr. Stoller, it's my understanding that in case 23 CR 001788C, you wish to plead guilty to criminal trespass. Is that correct?
Yes, Your Honor.
Are you under the influence of any drugs or alcohol this morning?
I have not.
You've been represented by counsel. Are you satisfied with his representation?
Very much so.
You understand that you have a right to a trial by jury on this charge, and that by pleading guilty to it, you're giving up your right to a trial by jury?
Yes, I do, sir.
Has anyone forced or coerced you to plead guilty?
Not at all.
I'll accept the plea as negotiated, Mr. Stoller, and you know you can't go back to that Walmart, right?
I absolutely do, sir. Thank you.
Okay, all right. Good luck to you, Mr. Stoller.
Thank you, sir. Take care.
Position 16, Jenkins.
And what is the announcement on position 16, Mr. Dotis?
I'm waiting for Mr. Walker. I just sent him a message. Mr. Jenkins, position 16 is also add-on 2 on the calendar. Okay, now, okay, he answered. I believe that position 16 will be a non-negotiated plea, and position add-on 2 on the calendar will be a negotiated plea.
And what's the issue with position 16 as far as it not being negotiated, Mr. Dotis?
My apologies, Your Honor. I'm sorry. I'm like cramped in the back here.
No, you're
The only
fine.
issue is restitution at issue. I wasn't given an amount or a legal basis, and I'm not clear if the items were returned.
Mr. Walker?
The amount listed in the warrant is $509, and it details an itemized list of what was taken. So,
Okay. And what is the offer on add-on 2?
a second. I'll put that up. It is 12 months to serve, 14 days, credit for time served, 7 days, balance probated, and a $500 fine, and a stay away from the incident location, which is the World of Beverage, located at 8455 Sonoa Road.
Okay, and so Mr. Dotis, so that's going to be a negotiated plea, correct?
Yes, Your Honor. Mr. Walker, I was having trouble hearing that. Could you type that address in the chat for me?
Yes.
Thank you.
We have a lot.
Not at all. Yes.
And Mr. Walker, given that it's not negotiated for position 16, can you tell me the facts of that?
Yes, the defendant went to a liquor store and he stole multiple bottles of tequila, totaling to the amount of $509. Obviously, this was captured on surveillance footage. The suspect was not at the scene at the time the police arrived, but after reviewing the footage, the officer did take out a warrant for theft by shoplifting, and it was itemized that $509 worth of liquor was taken from the location.
And what's the location?
It's the World of Beverage.
Oh, it's the same one?
And Your Honor, I don't believe that's the correct
Let me
arrest warrant. This incident occurred on February 22nd. I believe what Mr. Walker is referring to is a warrant that was issued on March 16th. So it's non-negotiated for position 16. The incident was on February 22nd.
Give me 1 second, I have to double check. Okay, sorry, different liquor store. The name of the liquor store in position 16 is Grapes and Grains, and that address is 3719 Old Alabama Road in Alpharetta. So it's,
And is that the one where you have the itemization, Mr. Walker?
let me just check one more time, make sure. Yeah, so on this warrant, there's itemization as far as what was taken, and I did list the incorrect amount for position 16. It's actually $448.96 to grapes and grains, and then add on 2 is the 509. But
Okay.
in this case, it was also tequila that was taken, and those bottles are itemized at $448.96.
$448.98.
Yes,
Okay.
at grapes and grains, and that also was several bottles of tequila that was taken from that
Okay.
location.
So just so that I'm have an understanding, add-on 2, the negotiated plea did not include
It
any
did
restitution.
included a fine.
Okay, all right. So, Mr. Dodas, as far as position 16 goes, since there's an itemization, I am going to require that he make restitution of that amount. So if he wants to continue with the non-negotiated plea, just know that I'm going to have him pay the restitution.
Understood, Your Honor, and I would just, Mr. Jenkins is on 4 North. I would just ask him, now that you know that there's restitution, do you want to go forward with these pleas to resolve your case? Or do you want to hold it off?
I'll pay it.
Okay.
Okay. Let's see, anything further, Mr. Walker?
Nothing from the state.
Okay, Mr. Dodas?
Nothing regarding this plea. Your Honor, we do stipulate to the factual basis, venue, and ID. We would request Mr. Jenkins to go to non-reporting status upon completion of the anti-theft course and payment of all fines and restitution, as well as if this court would cut Mr. Jenkins a break on probation fees so that he can attend these classes and ensure that he's paying all of this off.
Any objection to non-reporting?
No objection, Your Honor.
Okay, and I think that he should be able to get this done relatively quickly, Mr. Dodas, so I'm not inclined to waive any fees at this time. Ms. Strong, did you get all that, or do I need to
I
have
do
them
not.
repeated?
Can we go through both again, please, just to make sure that I have everything correct?
Okay, so from my understanding that in position 16, it's 12 months to serve 30 days, credit for time served 15 days, balance probated, restitution in the amount of $448.96, a theft course, and stay away from the grapes and grains. And for position add-on 2, 12 months to serve 14 days, credit for time served 7 days, balance probated, a $500 fine, and stay away from the world of beverage. Is that correct?
Correct.
Okay.
Thank
Did you
you.
get that, Ms. Strong?
Yes, sir.
Okay, very good. So I'm going to go ahead and take the plea now if there's nothing further. All right, Mr. Jenkins, good morning. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video. Do you agree to have your case heard by video?
This meeting is being recorded.
Hear me, Mr. Jenkins? You're going to have to answer verbally for me because we're having some. Okay, can you raise your right hand for me? Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yeah.
Okay, you can put your hand down. Thank you, sir. It's Mr. Jenkins, it's my understanding that in case 23 CR 002560A, you wish to plead guilty to theft by shoplifting, and in case 23 CR 002767C, you wish to plead guilty to theft by shoplifting. Is that correct?
Yeah.
Are you under the influence of any drugs or alcohol this morning?
No.
You've been represented by counsel. Are you satisfied with his representation?
Yeah.
You understand that you have a right to a trial by jury on these charges, and that by pleading guilty to them, you're giving up your right to a trial by jury?
Yeah.
Has anyone forced or coerced you to plead guilty?
No.
I'll accept the plea as negotiated, the pleas as negotiated, Mr. Jenkins. As soon as you complete the terms of the probation will go to a non-reporting status, okay? So the sooner you get this done, the sooner you won't have to report to probation, okay?
All right.
All right, good luck to you, sir. Who do we have next?
Position 27, Walker. No, that's right.
This is an unnegotiated plea on 27 and 28. It's one of those things where you have to say, it is what it is. He's trying to raise the money for the purge, and he's hoping that his family will raise the $380 by approximately the end of this week.
Okay, let's see. Good morning, Mr. Walker. I'm Judge Eric Morrow. This is the state all-purpose calendar. Do you agree to have your case heard by video? Thank you. Can you raise your right hand for me? Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth? Thank you. You can put your hand down. May I get his history, please?
Yes, Your Honor. Looks like the defendant has 13 arrest cycles. He does have a felony conviction out of Clayton County outside of the 10-year period for terroristic threats and acts. He received first offender treatment on that case. And the first offender was actually revoked October of 2002. As probation violation, well, at least one probation violation. It's like an additional felony conviction out of the 10-year period, outside of the 10-year period. He has at least three violations of probation, 3 felonies outside of the 10-year period. Let's see. And it looks like last arrest was for a probation violation. Arrest date was September of 2022. Nothing to add here.
Mr. Walker?
Yes, and just to add some clarity, I'm showing a reckless conduct and a battery family violence. That's case number 18 CR 009-509Y. That is with the same victim, Ms. Young, who's also on the line currently. Also, I'm showing a 2009 armed robbery conviction. Pretrial might have spoke to that, but it was a 2009 armed robbery and aggravated assault, and he was sentenced to 10 years of confinement. In this case, law enforcement was dispatched to 3749 Campbellton Road to a dispute with weapons call. Upon arrival, they spoke with the victim, Ms. Young, who stated that the defendant became aggressive with her and he pulled out a firearm and pointed it at her and threatened her. At that time, he did go outside to the driveway and kick in her car door, and he did leave the scene. An arrest warrant was taken out for him at that time. Ms. Young is on the line, so I would like the court to sound for her. The state's recommendation for this is 12 months to serve, particularly because it was alleged that a firearm was pulled out on the victim, and there is another battery family violence and reckless conduct conviction with the 18 CR number that provided to the court with the same victim.
I'm a bit confused, Mr. Walker, because on my calendar, Mr. Walker's charged with criminal trespass and damage to property.
That's correct.
Okay, so
he was charged for kicking the door into her vehicle, but I'm just giving the basis as to what was included into the police report as
okay.
The victim. And we also are asking for, I checked our notes, we also are asking for restitution for the victim in the amount of $2,000.
Okay, and is it Miss Young?
Yes.
And what's the first name? Oh,
I'm not sure if I pronounced that right.
Ms. Young, I see you there. If you would like to address the court, this is your opportunity to do so. You, of course, do not have to address the court, but if you would like to address the court, I'll need for you to activate your camera, unmute yourself, and I'll have to swear you in, okay? Okay, I take it, given that I did not get a response, that Ms. Young does not wish to address the court. Yes, Mr. McLean.
Your Honor, he does assert there was no gun involved, and Your Honor, that's, he is pleading guilty, unnegotiated to the allegation of stomping, I believe the phrase was the car door and the handle, and that caused damage. We've not heard the figure of $2,000 before now. Imagine there would be a document of an estimate for the repair of the car door handle and perhaps the door, but I'm struggling with the concept of $2,000 for a car door. So the main reason he's pleading unnegotiated, Your Honor, is he'd like to point out that this is alleged to have occurred back in June of 2021. He has had cases that have been adjudicated and resolved since then. He remembers the September of 2022, which is less than a year ago, being arrested on that other 21 CR case. And he was seen by the court, it was Judge Law, I believe, in approximately October, but I think it was more like November of 2022, and received the resolution of that case. Because it's a door handle and a door, he would like to ask the court to give him considerably less than 12 months on it. He's here in jail, Your Honor, on something else, which has to do with a traffic offense in which he's accused on a felony level of a chase. He's got lawyers on that. He'll deal with that case. That is not resolved. It's not anywhere near close to resolving yet. But Your Honor, this is from 2021. It is approximately 2 years old, and it's a car door. So we're asking for the court's consideration to give, say, 3 months to serve or something more, 4 months to serve, something in that neighborhood the most.
Okay, let's see, Mr. Walker, aside from just the stated figure, do you have any documentation of any
No, that's the amount.
damage?
That was the amount that was provided by the victim to our victim advocate.
How much time has he, will he get credit for?
He was basically 4 days back in 2021, and currently he's in on the felony charge. Does this show up? Does this particular 21 CR?
I'm looking at it right now. I do not believe so. No, he's in on the felony charge and the child support case.
Right. So, Your Honor, it's 4 days from 2021, literally, on this case. And loosely, we sometimes think of credit for, they know he's in, why bother to file it? But we won't go there.
And again, Mr. Just so I have it correct, Mr. Walker, the stairway address is 3749 Campbellton Road.
Yes, Your Honor, that was the incident location.
Okay, and no further contact with Ms. Young.
Correct.
All right, anything further before I take the plea?
Nothing to add, Your Honor. Thank you. He stipulates the 3 necessary elements and asked for to accept the plea.
And I will say, if defense takes the issue with the restitution amount, we can schedule for a restitution hearing, but that is the amount that was provided to our victim advocate by the victim.
Okay. Mr. Walker, it's my understanding that in case 21 CR 003085Y, you wish to plead guilty to criminal trespass and damage to property, and in case 23 CR 002567Y, you wish to plead guilty to abandonment of dependent child. Is that correct?
Yes, sir.
Are you under the influence of any drugs or alcohol at the present time?
Yes, sir.
You've been represented by counsel. Are you satisfied with his representation?
Yes, sir.
You understand that you have a right to a trial by jury on these charges, and that by pleading guilty to them, you're giving up your right to a trial by jury?
Yes, sir.
Has anyone forced or coerced you to plead guilty?
No, sir.
I'll accept your guilty plea, Mr. Walker.
I apologize. So he's taking the plea to the abandonment of minor child too?
No, just 27.
Oh, okay, that's, okay.
Okay, so he's gonna pay the purge amount for of 380, is that right?
He's doing his best. His brother is hoping to deliver that money to the appropriate place by the end of this week.
Okay, all right.
That is the hope.
So
It's a purge, so that's the way they work.
the sentence for position 27, the criminal trespass and damage to property will be 12 months to serve, 120 days, credit for time served 4 days, balance probated, an 8-week anger awareness class, no further contact with Ms. Young, stay away from the 3749 Campbellton Road address. And once he completes the anger awareness class, the probation will go to a non-reporting status.
Thank you, Your Honor.
Good luck to you, Mr. Walker.
Position 22, Mr. Rutledge.
That's the person that I haven't spoken with yet. He was unavailable yesterday. If we get that in a moment, Your Honor.
Okay, so can we get you to, I guess, 5 North? Can we get him to a phone?
Yes, I'll call the courtroom.
Okay, thank you. We appreciate it.
All right.
Judge Moore?
Yes.
I have a question for the ASDs. Mr. Walker, that position would be purged to pay. So even if he does pay the purge to get out of jail, we're still going to have an open CR case number for him.
Okay. Are you asking what we're going to do with it? Is that
right?
He
So we
pays?
need a.
If they pay, we typically do dismiss it, but that's
okay.
That's typically what we do. But if he pays, if counsel will just reach out to us and let us know that it's been paid and he's been released, I'll submit an all price.
Okay, I was just wondering because he's still going to be holding on that case until he pays that purge. And
Correct.
He's sitting in jail, haven't been on the SAP count. So I mean, we still have to have some way to track the case.
Okay. Did I answer your question?
I mean, we can send it back to the division, but
that's what we typically do. I mean, he has to pay the amount to get out. But once they satisfy the amount, we typically do null price the case.
Okay, so we'll just reset it back to the division then. All right, thank you.
I guess we'll be in recess until someone's ready.
Your Honor, we're ready with position number 6.
Okay, thank you. And what are we doing with Mr. Cooper this morning?
Ms. Cooper.
Oh, I'm sorry. What are we doing with Ms. Cooper this morning?
Your Honor, we're going to waive Ms. Cooper's arraignment and request to address bond.
Okay, What is the history?
Your Honor, it looks like the defendant has only one arrest. That was in April of 2020 for armed robbery, possession of firearm or knife during commission or attempt to commit certain felonies, aggravated assault. It looks like that case was null pros March of 2022, and no other history, Your Honor.
Okay, Mr. Young, what are the facts and what is the current bond?
Yes, Your Honor. The facts in this case is that on April 25th, 2023, law enforcement responded to 1935 Allison Court Southwest, apartment N30, in reference to a domestic dispute. The accused told law enforcement that she pushed the victim and he struck her twice. However, the victim, Victor Sanchez, stated that she punched him in the face, causing a bleeding lip when he was trying to leave. The current bond is a $1,500 surety bond, and the state would ask that bond to stand.
All right, Mr. Dodes.
Thank you, Your Honor. I will get to the facts in one moment. Ms. Cooper is 22 years old. She has been in custody for the past 15 days on a $1,500 surety bond, which she cannot afford to pay. So we would request a signature bond as Ms. Cooper maintains her innocence and wants to be part of her defense. As we heard from pretrial, I didn't hear any history or convictions or any history of FTAs or VOPs. So I believe that she's clear on reporting to court and will not miss any dates. I have a good phone number for Ms. Cooper. She's also a lifelong resident of the state of Georgia. At this point in time, I do have a good address for her. It is the incident location. So we would ask for a sheriff's escort to confirm that the alleged victim doesn't live at this address. Ms. Cooper also has family in the area. She has a mom that she's learned was in Grady after an accident on a bridge. She's not clear on if she's still at Grady, but she does want to be released to ensure that mom is being taken care of. She also has a sister in Bankhead that I don't believe she's been able to have contact with while in custody. She also has a 3-year-old child, Malia, who lives with his father for the time being, who's not the alleged victim, but she does want to continue being a part of her child's life. Ms. Cooper is in the process of getting her GED, and she tells me she took and passed the reading and social studies sections. She was in the process of finishing up with the math and science sections, which is all she needs for her GED. And she is going to, upon release, finish that up, as that's something that's very important to her. She is currently looking for work and was in the process of interviewing at a Goldberg's, and she's hoping that that is still an option. She's not clear on that. And then to go into the facts of this, in the warrant, it states, Ms. Cooper tells me that the alleged victim wasn't living at location. I do think it's important to note that Ms. Cooper in the warrant did call law enforcement and stated that her boyfriend at the time was coming to the location to retrieve toiletries. Ms. Cooper did not want him at the property anymore, and she tells me that the owner of the house or the apartment did not want him at the property, so she tried to have him leave the door. It stated that she pushed Mr. Sanchez out the doorway because he was refusing to leave. Once it escalated, she did call law enforcement. She does not want to have any more issues with the alleged victim. She doesn't want to have any more interactions. So she's fine with no further contact. As stated earlier, we would request a sheriff's escort to that location to confirm that the alleged victim doesn't live at the address. Ms. Cooper also tells me that the alleged victim took her phone, and so we would ask for either a one-time escort or meetup at the police station be included to ensure that the alleged victim can return Ms. Cooper's property so that she doesn't have any issues with staying in communication with the court or her attorneys while waiting on this case.
Okay, so Mr. Dodos, I'll convert the good bond into a signature bond through the jail with the conditions that there be no further contact with the alleged victim, She can go back to the location with the escort of law enforcement. If the alleged victim is not there, she can stay there. If he is there, then she's going to have to gather her belongings and find someplace else to live. In regards to the phone, there can be a third-party transfer, but there can be no contact with the alleged victim, no drugs, alcohol, weapons while out on bond. Were those all the conditions? Were there any other conditions on the previous bond, Mr. Dotis?
I think that covers everything to my knowledge after.
Okay. Okay, all right. Good luck to you, Ms. Cooper.
Thank you. Can you mute that for a second, Laura? Can you mute it? Okay.
And just to note that we still have the interpreter on the line. So as soon as we can deal with that.
We're ready on Rutledge.
Here on 3 South, I have position number 4, if you're ready for that person.
And Your Honor, Mr. Rutledge is a not guilty. We will waive the formal reading, ask the court to tell him about court dates and maximum punishment, and that will conclude that.
I'm sorry, Mr. McLean, I'm not sure who you're speaking of.
Rutledge, Mr. Rutledge.
Position 22, Your Honor.
22. That's going to be an arraignment.
Did you guys do that?
Okay. So when Mr. Rutledge comes before me, it'll be an arraignment. Is he?
He's here. I mean, he's on Zoom. He's the person in which 5 North was it?
5 North.
That's the 5 North imagery on the Zoom.
Okay. Good morning, Mr. Rutledge. I'm Judge Eric Morrow. This is the state all-purpose calendar that we are conducting by video. Do you agree to have your case heard by video?
Good morning.
Good morning, sir. And do you agree to have your case heard by video?
Yes, sir.
Okay. Can you raise your right hand for me? Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Okay, you can put your hand down. Mr. Rutledge, you've been charged in case 20 CR 003911J with battery, family violence, and cruelty to children in the 3rd degree. These charges carry a maximum penalty of 12 months in jail and/or $1,000 fine. It's my understanding, Mr. McLean, that you waive formal reading of the accusations. Is that correct?
Correct, Your Honor. I have explained to him what they are. We have copies. We were not able to see them because of a floor altercation yesterday, but I believe he is sufficiently apprised of the elements of what he's accused of.
Okay. How do you plead, Mr. Rutledge? Guilty or not guilty?
Not guilty.
Okay, we'll record your not guilty plea. Your case will be returned to the division judge, and you'll get notification of your next hearing date, sir. Good luck to you.
All right, thank you, sir.
You're welcome. Okay, now I think we can go to 3 South, and that's position 4 and 5, I believe, Ms. Camps.
Yes, how you doing?
Good morning.
Good morning, how you doing?
I'm well, Ms. Camps. Let's see. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes, sir.
Okay, can you raise your right hand for me? Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, sir. Nothing but the
Okay,
truth.
you can put your hand down. Thank you. And this is going to be a non-negotiated plea. Mr. Dotis?
Your Honor, after a further discussion with the state, I believe this will be a negotiated plea.
Okay, can you give me, or can someone give me the what the negotiated plea will be for both charges?
Yes, Your Honor. For both charges, it'll be 12 months or 34 days, credit for time served, 17 days with the balance suspended, and to stay away from the Hilois apartments for the loitering, and to stay away from the Sorrell apartments in regards to the criminal trespass.
Okay, is that your understanding, Mr. Dotis?
My understanding is it'll be time served. I would ask to correct the jail time. For position 4, Ms. Camps only has credit for 3 days, so we'd ask for it to be worded as serve 6 days, credit for 3 days. For position 5, as of today, she has credit for 15 days, so we'd ask it to be worded as serve 30 days, credit for 15 days.
And the state agrees with that. I'm sorry.
Thank you.
Okay. Anything further before I take the plea?
Nothing, Your Honor. We do stipulate to the factual basis, venue, and ID for the purpose of this plea.
And Ms. Strong, did you get all that?
I wanted to, what was the time on position number 4 again?
6 days to serve 3 days.
Thank you.
Well, no, yeah. Serve 6 days, credit for time served 3 days. Ms. Camps, it's my understanding that in case 23 CR 001390Y, you wish to plead guilty to loitering and prowling. And in case 23 CR 002555Y, you wish to plead guilty to criminal trespass. Is that correct?
Yes.
Are you under the influence of any drugs or alcohol this morning?
No, sir, I don't do that.
You've been represented by counsel. Are you satisfied with his representation?
Yes.
You understand that you have a right to a trial by jury on these charges, and that by pleading guilty to them, you're giving up your right to a trial by jury? You don't want a jury trial, do you?
No.
Okay. Has anybody forced or coerced you to plead guilty?
No, sir.
Okay. I will accept the pleas as negotiated, Ms. Camps. Now, you do realize you cannot go back to these Lois apartments or the Sorrel apartments, right?
Yes, sir.
All right. Good luck to you, ma'am.
Thank you.
Judge Morrow, we're ready for the interpreter case, position
Oh.
25, Mr. Romaine.
Okay.
We're ready to do a breakout. We're ready to do the breakout.
All right. So, good morning, Madam Interpreter. Thank you for your patience with us this morning. We appreciate it.
Good morning, sir. My pleasure. No problem.
So if we can put courtroom 2 into a breakout room with Madam Court Reporter, with Madam Interpreter. And I guess we will be in recess until they return.
Your Honor, briefly, and sorry to interrupt, is there any way we could do a breakout prior to that with just the court, me and Mr. McLean? I'd just like to give the court some context about this case that I think would be productive.
Do we need to go into the breakout room with you first, Mr. Walker, so that he can
preferably?
Okay. Do you hear that, Mr. McLean?
That's fine, Your Honor. There are no other inmates in the room at the time.
Okay, so why don't we do this? Why don't we all go into the breakout room, myself, Mr. Walker, Madam Interpreter, and then once Mr. Walker completes what he needs to tell the court, then we'll come back out of the breakout room and leave you all in there so you can discuss. Okay?
Oh, okay, Judge, I have it.
Okay, thank you, Ms. Grace.
Nope.
Okay, so we'll be in recess until courtroom 2 comes back.
You know, we got position to add on one, Mr. Demetrius Brown.
Okay, and let's see. Every courtroom 2 is in the breakout room with the attorneys. So as soon as they come back out, we will be able to go forward also with Mr. Brown. But the attorneys are all in a breakout room at the present time. So if you all would just be patient with us for a moment.
All right, thank you.
Thank you.
If possible, could I be put in a breakout room with 3 South? Thank you.
Ms. Grace, did you get that?
I'm sorry, what was that, Mr. Dotis? No, Judge.
My apologies. I might have been, my speakers were muted. If I could be placed in a breakout room with 3 South, I believe that's Mr. Brown.
Okay.
Thank you.
This meeting is being recorded.
Mr. Dotis, is there an announcement?
Yes, Your Honor. This will be a waiver of arraignment. We'll be entering a not guilty plea.
Okay. Mr. Brown, good morning. Your case will be returned to the division judge and you'll get notification of your next hearing date, sir. Okay, all right, good luck to you. Good luck to you, sir.
All right, you too. You too. Have a good one.
You also. Thank you, Mr. Dotis.
Thank you, Your Honor. And Your Honor, I do believe I see Mr. Jackson here. He's on the DVBW calendar if we want to handle that while we wait for the interpreter.
Thank you, Mr. Dotis. It appears that he's still trying to connect.
Every day, nothing down.
Okay. I have been in contact with him. I just sent him another text message, so hopefully he knows. Can you hear us, Mr. Jackson? Mr. Jackson, can you hear us? It looks like he's gonna have to get someplace more stable, Mr. Dotis. Okay, Your Honor, I'll try to see if I can give him a call or something. Not sure what's going on.
Okay.
Can you let him know when he logs on, he needs to accept the audio video settings?
Okay.
So his video came on, but his audio never connected.
Just accept audio and video settings, you said, Mr. Jordan?
Right, so he may want to log off, and when he comes back on, because it'll ask you, do you want to accept?
Okay. I'll try to give him a call real quick.
The,
Hey, Mr. McLean, are we ready to proceed?
Yes, Your Honor, we were able to take advantage of the presence of both the social worker and the interpreter to make phone calls while we were in the middle of talking and getting more information than ever before about Mr. Hurtado himself and the previous medical matters. Therefore, Your Honor, what we're seeking to do is in person, I'm going to be talking with Atlanta Mission today. They talked to us about the standing in line and the 6:30 a.m. necessity of being in line. We're going to try to get around that. We'd like to reset this case to Thursday. We'd like to ask Mr. Jordan to have the same interpreter who's already familiar with the case available to us on Thursday, because she says she is available for that date if we go ahead and put that in now. So we'll go ahead this morning. What time is it? And it's not quite 11. We'll put in a request for the same interpreter for Thursday, and we hope to announce his actual placement. We've got his sent to his consent on a written form for the release of medical information. So our main priority will be getting hold of the housing, and our second priority will be trying to hunt down that diagnosis to help Grady move even faster. The third priority is we're going to talk to the jail staff here. We anticipate that he would be out by, say, Thursday night or Friday, going according to this more detailed plan.
Okay, thank you, Mr. McLean. So we'll reset this case until Thursday. Let's see, and there's no problem, Mr. Jordan, of us getting Madam Interpreter back on Thursday. That would be helpful.
No, Your Honor, it's not a problem at all.
Thank you.
Okay, all right, thank you. We'll see you back on.
That will be at 9 a.m. Is that correct, sir?
That's correct, yes.
All right, thank you. Have a good
Okay,
day.
thank you. We appreciate it.
You're welcome.
So we still have a couple more on the 11 o'clock calendar. I believe position number 11.
Yes, Your Honor, we're trying to bring him. He wasn't on the full sheet by mistake, I believe. So, yes.
Okay. And position number 18, I just don't know what we're gonna do with.
We're going to, Your Honor, he was a do not bring situation. We'd like to reset that at least a week and a half, 2 weeks. In the meantime, I'll have a social worker talk to him and see if that actually needs to go to competency calendar as opposed to making progress. Maybe you never can tell, maybe it's just a bad day.
So we'll reset it 2 weeks out then.
Very good.
All right, so we're holding for position number 11, and if anyone on the DV bench calendar comes on, then we'll handle those two also.
Here's Mr. Green.
Oh, Mr. Green, Your Honor, we're already on position 11. My apologies.
Okay, so that's going to be a negotiated plea.
Yes, Your Honor, he's position 11 and 12. Position 11 will be negotiated, and then position 12, it's my understanding, has been transferred to the DA's office.
Okay. Good morning, Mr. Green. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video. Do you agree to have your case heard by video?
Good morning, sir. Yes, sir.
Thank you. Can you raise your right hand for me?
Yes, sir.
Do you swear or affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Okay, Mr. Green, you can put your hand down. Thank you. Mr. Young?
Yes, Your Honor. The plea in this case is 12 months to serve 30 days, credit for time served 15 days with the balance suspended, and to stay away from MARTA. And I believe that is on all counts.
Okay. Mr. Dutters?
Yes, sir. That's our understanding, and we do stipulate to the factual basis, venue, and ID. As this incident did occur on MARTA, We would ask if it could be worded to comply with all active MARTA suspensions so that when those suspensions are lifted, Mr. Green won't be prohibited from traveling using public transportation to get around the city.
Okay. Mr. Green, it's my understanding that in case 23 CR 002529C, you wish to plead guilty to public drunk, obtaining unlawful entry into MARTA, and 2 counts of disorderly conduct. Is that correct?
Yes, sir.
Are you under the influence of any drugs or alcohol this morning?
No, sir.
You've been represented by counsel. Are you satisfied with your counsel's representation?
Yes, sir, I am.
You understand that you have a right to a trial by jury on these charges, and that by pleading guilty to them, you're giving up your right to a trial by jury?
Yes, sir, I do.
Has anyone forced or coerced you to plead guilty?
No, sir.
Okay, I'll accept the plea as negotiated, Mr. Green. You're to comply with any active MARTA suspension, so you can't go back to MARTA until they allow you to be there, okay?
Yes, sir, I understand. Thank you, y'all.
All right, you're welcome. Good luck, Mr. Green. Ms. Strong, is there?
I just wanted to make sure that, wanted to confirm that all the other charges will be one and concurrent.
Yes.
That's correct.
Thank you.
Okay. Let's see, I think that completes the 9 o'clock calendar. Ms. Strong, whenever you're ready, let's go over that calendar as we wait for the DV bench warrant people to come on with us.
One moment, please, sir.
All right, we're completed here in courtroom 2, Judge Morrow.
Okay, thank you. We appreciate it.
Thank you. Have a good one. I'll see you
Do the
later.
same. Yes, are you with us this afternoon?
Yes.
Okay, I'll see you this afternoon.
All right, thanks. Bye.
Thank you.
You ready?
Yes, Ms. Strong.
Position number 1 was waive arraignment, reset jail jury. Position number 2 and 3 were waive arraignment, reset jail jury. Position 3, waive arraignment, reset jail jury. Position number 4 and 5 were negotiated plea. Position number 6 was reset jail jury. Position number 7, 8, 9, and 10 were reset for the competency calendar on June the 8th. Position number 11 was a negotiated plea. Position number 12 was transferred to the DA's office. Position number 13 was released, reset further notice. Position number 14 was reset for Thursday's SAP calendar. Position number 15 was waive arraignment, reset jail jury. 16 was negotiated plea. Position number 17 was reset further notice, the defendant was released. Position number 18 was reset for May the 23rd. Position number 19 was a negotiated plea. Position number 20 was reset for Thursday's SAP. And also his FTA will be reset for Thursday as well. Position number 22 was arraigned, reset jail jury. I don't have 23.
That was out, so I guess we'll have to reset him.
Would you like me to reset it for next Tuesday?
Yes, that'll be fine.
Okay. Position number 24 was a negotiated plea. Position number 25 was a negotiated plea. Position number 26, was that Ms. Rockwell's case? Or was that another private attorney?
No, that was Mr. Kelbaugh's case, and it's going to be returned to the division judge.
Okay, thank you. Position number 27 was a negotiated plea, and position number 18 will be reset further notice. I'm sorry, did I say 18? I meant 28. I apologize.
Okay. And the add-ons?
Thank you, Judge. Position number 1 was waive arraignment, reset jail jury. Position number 2 was a negotiated plea, and position number 3 will follow his other cases and be reset for the competency calendar on June the 8th.
Okay, thank you. So I see Mr. Jackson there. Mr. Jackson, can you hear us? So Mr. Jackson, I don't know if he can hear us. It's a little after 11. Is Mr. Walt Hall on with us?
Yes, I'm here, Judge.
Yes, sir, Your Honor. I can hear you. I'm sorry.
Oh, no, you're fine. Is this Mr. Walt Hall, Andre Walt Hall?
Yes,
Okay, and Mr. Dodos, are you representing Mr. Walt Hall?
Mr. Walhall is a conflict. It was listed as Dennis Murphy. I sent him the DVBW calendar, but he will need a conflict attorney.
Okay,
And I believe counsel has already been appointed as PD Dodos just stated.
okay, so Mr. Let's see, can someone give Mr. Murphy a call to see if he's going to join us this morning?
Okay, Judge, I'll reach out to him.
Thank you. So Mr. Walt Hall, if you'll just hold on for us for a moment as we try to raise your attorney, okay?
yes, sir.
Thank you. And Mr. Jackson, I don't know if he's still having connection problems.
No, sir. No, sir, Your Honor. I
Oh.
can hear you now, Your Honor. I can hear you now.
Oh, okay. Are you able to activate your camera, Mr. Jackson?
But it's showing me that my camera is on. I don't know. Is it on? Can you see me?
No, I can't see you, Mr. Jackson. It just has your name there. Okay, there you go.
Okay.
All right. All right. Good morning. I'm Judge Eric Morrow. This is the DV bench warrant calendar. Mr. Walker, I take it that Mr. Jackson missed a hearing.
Yes, he missed the arraignment calendar on January 12th of this year. He was out on a $10,000 surety bond. It's the state's position that even though the defendant did move, it is the defendant's responsibility to update any change of address with the clerk of court. I did review the file in Odyssey. There was no return to sender. So we're asking that the bench warrant remain intact. And just to give a little history, he does also have a previous 2020 battery family violence conviction.
Listen, if I have to keep telling.
Mr. Dodes?
Yes, Your Honor. I spoke with Mr. Jackson last week. I've had good contact with him. And as stated, I spoke with him about getting on early today. I'm glad we did to make sure no issues with getting connected. He wasn't able to connect. So I'm glad we got to address this today. This is a case from back in 2019. Since that time, Mr. Jackson did briefly move to North Carolina and he moved back. This case did occur so long ago, and with the COVID pandemic, Mr. Jackson had the mistaken belief that he didn't need to keep checking in with the court to make sure of any upcoming court dates. He's clear that moving forward, he does need to check in, even though they do have an updated address, at least every month to make sure he's making any positions. And he's clear that this case isn't just going to go away or pinned forever. Additionally, as soon as he learned about the bench warrant, he immediately went to the court to fill out the updated contact sheet. I don't believe he's had any issues since 2020, no issues with the alleged victim or anything like that. I didn't hear any other FTAs or any other issues reporting to court. So we would ask Your Honor to give Mr. Jackson another chance and set aside this bench warrant. Again, his contact information I was able to verify, it's correct on Odyssey now. So he should be getting all of his mailings. And as a fail-safe, he's clear that at the latest, once a month, he needs to check in with the court. So he's at every court date.
Okay. Mr. Jackson, it's the policy of this court that I'll set aside a bench warrant on one occasion. You do know that it's up to you to make sure that the court has a up-to-date address, and we should be the first people that you update your address with if you move. So I'm going to set aside this bench warrant on this one occasion, but if you miss court again, the bench warrant won't be set, and a bench warrant is issued, the bench warrant won't be set aside, okay?
Yes, sir, Your Honor.
All right. Good luck to you, Mr. Jackson.
Yes, sir, Your Honor. Thank you, Your Honor.
You're welcome.
Yes, sir.
Judge, I reached out to Mr. Murphy. He said he will be joining us.
Okay, thank you.
You're welcome.
Have a good day, Mr. Jackson. And,
Yes, sir, Your Honor. Thank you.
okay, we will await, Mr. Murphy. I don't think that we'll need courtroom 2, to be on with this, given that I think that this is the last matter we need to handle.
Correct, Your Honor. If myself and Attorney McLean could be excused, I believe that's all our business.
Okay, very good. I'll see you on Thursday.
Thank you, Your Honor. See you Thursday.
Thank you. Mr. Murphy, good morning.
Good morning, Judge. I was notified about Mr. Walthall yesterday from Angelo Dotis. He gave me a heads up that this was coming on the calendar. And it's a case that I was appointed on back in November by Judge Morrison. I've not received any discovery. And so I have no basis I have really nothing to go forward on in terms of facts of the case. It looked like it was on the calendar to address the sureties issue.
Right, apparently he missed the court date. And a bench warrant was issued.
That's right. I checked on Odyssey, and then I see where Judge Morrison had issued an order against the surety, and it looked like the last thing I saw on the docket, Judge, was the surety's motion to set aside the forfeiture amount. I didn't see anything else but I am here duly. And like I said, I wish I knew more. I don't have the discovery. I filed it a long time ago, and there's nothing on Odyssey showing it. So I don't really know much factually about it that I could help my client in terms of trying to get him possibly back out. I know obviously the surety's not going to go back out on the bond because the money's been forfeited.
Mr. Walker?
To answer counsel's, I guess, inquiry, we're here today because your client filed a set-aside request because he did bench warrant. I will say that he was initially released on a $4,000 pretrial release bond. He had a jury trial calendar with Judge Morrison on 11/7 of last year. It's the state's position. You have to keep up with your court dates. Even further, he was out on a pretrial release bond. So that leads me to believe that he has not been compliant with pretrial, because if he was compliant with pretrial, I'm thinking that he most likely would not have missed his court date. But nonetheless, he did miss the court date. He was already given a pretrial release bond. We're asking the set aside not be granted.
Okay. As far as when I Mr. Walker, unless I was incorrect, according to Odyssey, the motion to set aside was followed by a guy named Avril Walker, and it was on behalf of the bonding company.
Let me verify. I think that it was actually taken from your client, but 1 second.
And your client has your client has his hand up, Mr. Murphy. So I don't know if you need to discuss anything with him.
Yeah, it has your client's signature on it, so it actually
Okay.
your client filed the motion.
Okay, absolutely. Then if you're able to put me on a breakout room, I can have a discussion with him. But you're correct, Mr. Walker, that he did miss court in November, and I looked on the docket. It looked like that his court notice was sent back
back. Yes.
Me to confer with him.
Okay, so can we put Mr. Murphy and I guess Mr. Walt Hall is on the iPhone into a breakout room? Ms. Grace?
Yes.
Okay, thank you.
Thank you.
And we'll be in recess until Mr. Murphy and his client come back.
Thank you, Judge.
Ms. Grace. Ms. Grace,
Yes, Judge.
would you mind seeing if Mr. Murphy's going to be ready soon? And tell him if he needs more time, that I'm happy to have him come back on the calendar on Thursday, possibly.
Okay.
I just don't want to keep holding people up while he's conversing with his client.
Oh, okay.
All right, thank you. Yes, Mr. Murphy. You're on mute. You're on mute, Mr. Murphy. You're still on mute, Mr. Murphy.
I don't know how, am I
there you-
with you now?
Okay.
Sorry, Judge. I thought I touched the red button and we were in good shape. So Judge, my client indicated that him and a representative from Tara Bonding came down to the courthouse, I guess a week ago, and filed this. But we're in a strange situation because the pleadings clearly show it's Tara Bonding's motion to set aside. But again, we're here. My client has a stable address of 50 Mount Zion Road, apartment W6, Atlanta, Georgia, 30354. And in terms of the state indicating there was another case, Judge, that's correct. There's a 22 CP case, 210411, and that's for felony case, but he's in good standing there. So the case is still open, but he is in good standing. He is reporting as directed. I cannot say definitively why this case jumped off the tracks. He indicated that the grandmother had passed away right around that time. Again, I had no way to contact him, and I had no even incident reports to give me a clue to where he might have even been. I would ask the court to, under the authority that you may have, to allow him to stay out under the existing bond. I have a good contact number for him, and I have a stable address. And now that I have a phone number, I can relay whatever I need to him in terms of making sure that we return to court. But I do know that Your Honor, we are in a perplexing situation in so much as that the docket indicates that that Judge Morrison's court followed up after it was FTA, that ultimately Judge Morrison did forfeit the bond against the surety. So, and like I said, I do see, and I wouldn't misrepresent anything to the court, that when I first look at the motion, it is the motion of the surety, and it doesn't look like it's on behalf of my client. But nonetheless, while we're here, I would ask, Judge, given that he has that other open case, which he has reported as directed, to allow him to stay out on this existing bond, and not have to turn himself in on this misdemeanor case.
Were you appointed when the case was with Judge Morrison?
I was, Judge. In fact, Judge Morrison appointed me directly, and it was probably like in October, and then, like I said, in November, it did go to, my client was FTA. And again,
I guess my question was, if you were appointed in October, why wouldn't you have gotten notice also of the court date?
Judge, I did. I was there in November. I was.
Oh, okay.
I was there. And I had nothing to go on. And I was not aware of I was appointed last year. I was not aware of the 22 CP case, Mr. Walther. So like I said, I had nothing to go on, and nothing was able to get clearer for me because I never got any discovery. And to this day, there's nothing on Odyssey.
Well,
So I had nothing to bring a skip concentration.
Well, what I think I'm going to do is, since you were appointed, you're in Judge Morrison's, I think I'm going to return all of this to Judge Morrison so she can make a determination. So if you want to get on one of her calendars, so that you can get some resolution to all of this, I think that might be most appropriate, given that you were of counsel at the time that he missed that court date.
Judge, I appreciate it, because the last thing I said, and I'm not talking attorney-client privilege, was to Mr. Walther that ultimately a call needs to be made to Reed Martin, the litigation manager, to get us on a calendar, with or without the surety.
Right. So I'm going to allow you all to do that, and let that court make the determination. Okay.
Judge, I appreciate it, and as soon as I get a notice, I will get I'll at least have Reed Martin CC you, or I'll get you notice that we've taken that step. I'm going to call Reed Martin right now.
Okay. Very good. All right. Good luck to you, Mr. Walt Hall. And Mr. Murphy, you have a good rest of your day.
Thank you, Judge. I'm sorry it took me a minute to get on there. Like I said,
You're fine.
The case came in, and when I saw that paperwork, I hadn't seen anything like that before, but I guess there's something new every day. Thank you again for the courtesy. Thank you, Ian. Appreciate it.
Okay. All right. Thanks, everyone. We'll see you all next time.
I'm back.
Okay.